Welcome viewers. In this episode, we'll discuss human rights legislation in the United Kingdom with John Scott QC. John is a leading solicitor advocate and human rights lawyer in Scotland. During his time in the legal profession, John has served as the president of the Society of Solicitors Advocates. He's defended clients in both the High Court of Justiciary as well as in the Supreme Court of the United Kingdom, with one of the Supreme Court cases having been featured in the Channel 4 documentary, The Murder Trial. In addition, John has also been awarded Silk of the Year in 2018 and has recently been commissioned by Chief Constable Ian Livingston to lead the review of the use of powers by Police Scotland to enforce the Scottish Government's COVID-19 pandemic measures. So thank you, John, for joining us.
It's good to be here today, Rami. Thanks to you for the invitation.
Fantastic. So just on your role leading the review into Police Scotland, could you discuss what your role consists of and any notable points you'd like to raise about the review itself, that you think the public should be made aware of?
Sure, of course, Rami. It was a few months ago, I got a phone call from the Chief Constable. I think it was a text message initially, then a follow-up phone call. And it was just a couple of weeks after lockdown and the new regulations and the new legislation. And he was of the view that although there is permanent oversight through the Scottish Police Authority of Police Scotland, that the powers that they were being given to restrict the free movement of people were such that he thought that additional human rights-based oversight was justified. So I had a quick conversation then with the Vice Chair of the Scottish Police Authority, the acting chair, and we agreed to set up an independent advisory group. And the group has been operating. We met every week since we set up. And the plan is that we run through until the emergency powers lapse, which is supposed to be at the moment September, unless things change. And we're offering real-time advice. And that was in acknowledgement of the fact that legislation and regulations were introduced very, very quickly. Little time for the public to be told the new do's and don'ts. Little time for the police with their enforcement role to work out the do's and don'ts. And therefore it was recognised from a fairly early stage that mistakes would be made, honest mistakes would be made by the police and the public. And therefore it would be useful to have this group, which consists of those with policing oversight responsibilities, the statutory human rights bodies, Human Rights Commission, the Children's Commissioner, Equality and Human Rights Commission, independent academic with a specialism in data, human rights campaigners, Amar Anwar, Tressa Burke from the Glasgow Disability Alliance, and Brian Scott from the Glasgow Disability Alliance, an autistic person who has her own network, the Scottish Women's Autism Network, Katrina Stewart, and Elizabeth Kelly, a doctor who continues as a GP, but also has a deep background in helping government. So pulling all of that together to assist in trying to let Police Scotland know where there may be areas of improved scope for awareness, like in relation to those with hidden disabilities or who were autistic and who might need to be out more than the guidance permitted or more than regulations allowed. So to assist with that and to help Police Scotland and the public to an extent get it right, rather than, as with probably most reviews, including some of the reviews I've done, waiting till something had happened and then having a hindsight, not finger-pointing exercise necessarily, but rather more of that. This was with a view to helping Police Scotland to get it right as close to first time as possible, recognising that mistakes would be made, but realising also that this was a situation that wouldn't necessarily end soon. We may have a reintroduction of lockdown, or we may have, it appears perhaps more likely, localised lockdown, and therefore working out what's the best way of operating for Police Scotland and for the public. We looked at things like communication. We've looked at the fact that policing can't actually do this without the cooperation of the public, and clearly the cooperation, the adherence of the public to not only regulations but to guidance has been magnificent on the whole. And the police working with that, but as restrictions are eased, policing demands return to normal for the sort of crimes that they would be dealing with ordinarily. and therefore to a very great extent it relies on the public to do the right thing themselves, and most people are. There's a theme around inequality, which has been a wider theme of the pandemic, and those living in poverty, ethnic minorities, other minority groups, children and young people, and how things have impacted on them to perhaps a greater extent, and also how, in particular, for example, people living in poverty may not be as easily able to comply with some of the restrictions around lockdown. I mean, I've got a garden, so my kids can go out and play in the garden, but there's lots of people, lots of families living in circumstances where they don't have a garden. And so they need to get out at times to take the kids out, to go out themselves for their own physical or mental health, as well as just for exercise. And so it's to try and build all of that in, and that there would be an understanding and a level of tolerance on the part of Police Scotland, notwithstanding that in terms of surveys, which are very positive about Police Scotland, there's a hardcore of about 25 to 30% of the public that want to see more enforcement action. We had a public portal which was open, that's still open. And on the same day, there was someone who responded from the Western Isles and said they really appreciated the way the police were approaching it there, because while we still had the 5 mile restriction in place, guidance, they had to travel more than 5 miles to their nearest supermarket. And the local police had offered some reassurance, look, that's not going to be a problem. You don't need to worry about that. For some people, there was a concern. You think, well, can I still go to the supermarket? The local police were very good in that. The very same day that that response came in, someone said that it's all gone too far, the police aren't doing nearly enough, and martial law should be introduced. So the police have to try and navigate a course somewhere between you're doing a great job, good use of discretion, through to send in the army. And in general, I think that they've actually done that very well. But there's a public portal, it's on the Scottish Police Authority's website. Our reports to the Police Authority Board are there, along with minutes of our various meetings. And if people in particular who've had experience of the policing of the pandemic, good or bad, want to offer their views, then they can still do that.
Thank you for going into that so in depth. More broadly, on the topic of human rights, would you be able to provide us with a summary of the Human Rights Act 1998 and explain maybe the reasons why it was implemented in the first place?
Yes, the Labour government of Tony Blair is now very controversial, and it's hard to think back to a time when it was a blessed relief from a very long number of years of Tory governments, which had started with Margaret Thatcher in 1979 and then continued through after her. And Tony Blair, again, now hard to think back to those days, was seen as a reformer, as someone of the left, but kind of moderate left, but who wanted to do different things. And part of that was to embrace the idea of human rights. And we had, so happening round about the same time, where the idea of the Human Rights Act, but also the Scottish Parliament, we had the referendum, and then the Scotland Act. And the Human Rights Act and the Scotland Act for people in Scotland were intertwined. And actually, the aspects of the Human Rights Act came into force in Scotland in May 1999, which was about 18 months before the Human Rights Act came into force. They were supposed to, I think, come into force at the same time. And the idea was European Court of Human Rights, Strasbourg, a long way away. It was a consensus model involving a large number of countries, and they didn't always understand. There was a margin of appreciation, but they didn't always get the United Kingdom. We took some heavy defeats in important cases there. So why not let our courts do it? Why not introduce important aspects, the key aspects of the European Convention, direct into UK law, so that rather than having to go to Strasbourg, there would be a responsibility and a duty on public authorities to comply with convention rights, and there would be the opportunity for people in this country to use human rights directly in court here. And it was a really good idea. It was a nice way of doing it as well, so that parliamentary sovereignty was retained, but the courts could issue a declaration of incompatibility. And that's happened on a few occasions. And that was the nuclear option. That was the court saying, we can't quash this particular piece of legislation because of parliamentary sovereignty, but we're telling you that this isn't compatible with convention rights. And the scheme for the remedies there was that the Parliament, the government, should address any declaration of incompatibility as a matter of urgency. So it was quite a tidy solution. It dealt with some of the concerns about the European Court being too remote and taking too long, and it put a domestic badge on what was happening. And the courts in Scotland and in England, when their time came, embraced it as a means of driving up standards. There was a degree of reticence, there was a degree of suspicion, there was a degree of antipathy towards it from some. There was probably an understanding that it might mean reallocating resources or finding more resources in some places. But in general terms, the court responded fairly positively to it and did use it in the early years to drive up standards and to hold public authorities better to account. What then happened, though, was when resources don't necessarily expand sufficiently, some of the decisions that the courts were making were potentially going to result in criminal cases being thrown out or more money being spent on prisons. I mean, the slopping out case in Scotland actually did have that consequence eventually, although it was fought by the Scottish government. So the courts started to then slow down in their enthusiasm. And then there came a point where the courts, I think, resented the suggestion that you would have to quote European authority in order to argue for a fair trial. And the Scottish courts in particular started to bristle and say, well, we've always had for centuries the idea of a fair trial. You really don't need the European Convention. You don't need these new concepts or arguments. And then it became a bit more difficult, and certainly in the appeal court in Scotland, trying to raise arguments as devolution issues or compatibility issues, you were not as well received. And the fact that the Judicial Committee, the Privy Council, and then the UK Supreme Court could, in effect, change the law in Scotland, that really didn't go down very well at all. It didn't go down very well with the Scottish courts, and it went down, I think, probably even less well with the Scottish government. So Alex Salmond, when he was First Minister, and Kenny McCaskill was the Justice Secretary, after the Nat Fraser decision at the Supreme Court, made some comments which I would hope now, with the benefit of hindsight and some maturity, they would regret. Pretty personal comments about Lord Hope, how he only came up for the festival and didn't really know what Scotland was like, which is just wrong and, you know, personal and derogatory, and kind of toys out the pram, to be honest. And Alex Salmond, similar comments. Comments, in fact, from both of them, which I tried to use in an argument that Nat Fraser couldn't get a fair trial because of publicity around things said by the key government people, First Minister and the Justice Secretary, who have a responsibility for enforcing the rule of law. So, you know, really not a good look for them. But that decision in the Nat Fraser case and the Cadder decision then in 2010 went down like a lead balloon with some, and in the court in Scotland, it had looked at the question of solicitor access for interviews for suspects, and it said, no, it's fine, we've got enough other safeguards. So when the Supreme Court, including Lord Roger and Lord Hope, looked at it and said, nah, look, guys, you're way out of line. Having all of these other safeguards is beside the point. A trial starts in the police station, and the European Court had been pretty clear about that. So you need solicitor access. And thinking back on it, I mean, I've been involved with the Scottish Human Rights Centre, and we've been campaigning for some time, including giving evidence to the Committee for the Prevention of Torture, and saying solicitor access should be allowed. You know, it just goes without saying. But when it was introduced, there was a real kind of backlash, a suggestion that it was floodgates opening. The Crown fought the 𝙤𝙤 case and the subsequent cases. Two of the subsequent cases, the sons of 𝙤𝙤 and the grandsons of 𝙤𝙤, were cases I went to the Supreme Court with, and it wasn't a good look. You need, I think, to have a proper argument, but and therefore you need a contradictor. However, if you've got the Crown saying we don't think that people should be allowed access to a solicitor before they're interviewed by the police, you know, what would most people make of that? In fact, in Scotland, I think most people thought they had that right because they saw it in TV programmes and films from England or America. But they didn't. You know, in Scotland until 2010, very few people were allowed access to their solicitor before they were interviewed. I think it was a police officer gave an affidavit for the Supreme Court in 𝙤𝙤 suggesting that it was done. Not in my experience, which even at that point was pretty considerable. So we've kind of settled back down, and now devolution issues and compatibility issues, they still appear, but I think some of the early shine has gone off, and you would think twice before you make the argument by including a compatibility issue. And you know, even the courts in England have said if there's English or Scottish or UK authority that deals with the issue, then take us to that. Don't take us to Strasbourg first. But it does still happen. I think it's been a pretty interesting period of time since 1999, 21 years now. And during that time, in order to be a competent criminal lawyer, you need to be aware of far more law than ever before. And you need to be aware of law on the international stage as well.
Do you believe that the Human Rights Act 1998 sufficiently protects human rights in the United Kingdom? And if not, are there any reforms that you'd like to see implemented?
It doesn't, no. And you know, that's become increasingly clear that there's obviously a bit of a backlash, or an increased backlash, because since the Conservatives have been back in power at Westminster, every few months someone says, oh, we need to get rid of the Human Rights Act, and we need to stop being signatories to the European Convention. You know, unfortunately, that even the Tory party has got some saner voices in it, although they lost some of the same voices, like Dominic Grieve at the general election. So you know, from time to time, there's the lobby that says let's get rid of it. Let's have a UK Bill of Rights. To my mind, anytime I hear someone saying that, whatever they surround it with, what they're really saying is they want people to have fewer rights. They are not saying we want to go further. It's like the whole Brexit thing and the things that we won't sign up to in relation to, for example, workers' rights. It's not, as is sometimes claimed by some UK cabinet ministers, this is so we can have higher standards, because Europe's never stopped us from having higher standards. Europe only stops us from having lower standards, from dropping our standards. So, you know, unfortunately for too many people, Brexit is about reducing rights, about dropping standards, about chlorinated chicken. You know, what's so bad about chlorinated chicken? You know, what's so bad about having to shop in Tesco if you're poor? The folk that have got absolutely no idea. I mean, I live a very comfortable life. I went to a normal school. I dropped my kids off at the local primary school. So I'm still, I think, connected to reality. But my life is far removed from people in deprivation. But the people whose lives are far removed from my life, they're so far away from deprivation and people who have got genuine human rights problems that they can't see it. And what's worse is some of them don't want to see it. They don't care. They have got no empathy at all. So one of the things that's good about Scotland is, whether it's because the First Minister is also a lawyer, I don't know. maybe they're just a bit more compassionate. And there's lots of criticisms you can make of them, but they actually have got a warmth towards human rights that you don't get from UK government ministers. And so, for example, later on this year, there will be legislation to bring into direct force, in the same way as the Human Rights Act, the UN Convention on the Rights of the Child. So I've been working on the advisory group for police powers with Bruce Adamson, the Children's Commissioner, and one of his colleagues, Maria Galli. And they recognise that Scotland is trying to do the right thing around UNCRC, and the police and the justice system recognise that children and young people should be dealt with differently. We've got the Sentencing Council looking at the sentencing of young people and exploring the possibility that a different approach should be taken for those under 25, because the neurological development of the young person's brain continues up until the age of 25, and therefore we shouldn't judge them, so far as blame is concerned, in exactly the same way as a mature adult whose brain is fully formed. And economic, social and cultural rights. The review I'm chairing into mental health legislation, specifically in the terms of reference, which were already in the first draft, but there's reference to social, economic and cultural rights in the United Nations Convention on the Rights of Persons with Disability. So while the UK government's saying, nah, we don't like these foreign things, failing completely to recognise that the European Convention was pretty much drafted by English lawyers. And they're saying, no, it's not nothing to do with us. We don't want things going too far or too fast. The Scottish government's approach is, we've signed up to all these treaties, so let's take them seriously. Let's not just have them lying there and people think, well, that's a nice set of words. Let's bring these things into action. And the Scottish Human Rights Commission has done some excellent work around, for example, translating human rights into action so far as tenancy issues in Leith are concerned. So really positive things, and an embrace of the idea of human rights. Human rights, done properly, are going to be a challenge to any government, and they're a sword and a shield. And even the best government, you're going to find at times they're not doing the things that they should be doing in terms of human rights standards. So you have an approach to human rights that either says, let's find a way out of this, or, yeah, okay, let's find a way of making this work. And actually in Scotland, for all the criticisms, the outlook towards human rights is far more positive. Alan Miller, a former colleague of mine, a predecessor of mine as the chair of the Scottish Human Rights Centre, he's now leading work for the government on human rights as well. And there really is, I think, a sincerity about the idea of translating human rights into something of value for everyone, and to increase awareness of it so that people can be better informed about the rights they have and about how to enforce them. So more can be done, certainly, than the Human Rights Act, but actually in Scotland we are looking at that.
So you seem quite cynical about the idea of replacing the Human Rights Act with the British Bill of Rights. But do you think there are any merits, any benefits that there could be of potentially placing the Act?
I'm afraid not, no. And this is probably a debate that I'll continue to have with Haroon, our mutual friend. No, because unless you are going to aim higher, in which case you don't need to come out of these other things. Sign up to them and then be one of the leaders in the Council of Europe and say, hey guys, we're not lagging behind anymore. Copy us, we'll take the lead, rather than we're kind of dragged along with the rest. If I thought, and you'll detect my cynicism about the UK government, if I thought that there was a genuine desire to go further and do better, and that it was about looking at the full range of rights, economic, social and cultural, as well as civil and political, then I would welcome it. As it is, the framing of the debate is such that I just don't buy it. It's coming from people who have said things that make it pretty clear what their intentions are, and trying to spin it now, that doesn't really work. You can judge people by their actions as well as by their words, and I'm much happier in the Scottish context, and I think the Scottish government's approach to human rights which, for example, includes if the Human Rights Act was repealed, the Scottish Government, I think, is contemplating that it would enact within devolved powers effectively the Scottish Human Rights Act. I think that shows you where we are, but it also shows you where they are. There isn't anything to stop the UK government having higher standards. Human rights are a floor, not a ceiling. No one ever says in human rights monitoring bodies, oh, whoa, you've observed people's human rights too much. There's always more that can be done. But if your attitude is, actually, this is a nuisance, they don't get us. We like to do things different, and we're good guys. Now, unfortunately, when you look around the world, there are some people saying, "No, we're good guys. We don't need that," who are kidding themselves, but they're not kidding anyone else. So our approach, the UK's approach to human rights, especially given how instrumental we were in the European Convention, for example, that's watched by other countries. Other countries send observers over here. They monitor how we're approaching it, but so do some of the dictatorships do. And if they say, well, look at what the UK is doing, they're not bothered about this anymore, then it makes it that bit easier for them to continue to repress their people. So, we have a responsibility in human rights terms, not just to our own citizens, but to the citizens of the world. And we should be taking a lead and proudly saying, absolutely, we signed up to all these things because we want to, not just because everyone else is doing it. And actually, we're so serious about it that we want to push things on. We want these rights in living instruments like the European Convention to go further, because it's ridiculous. It's like the constitutional specialists in America who say that it's the founding fathers. What would they have done? Now, why should the world now be judged by, including in terms of people's rights and duties on states, by what happened hundreds of years ago? It's that I can't remember the expression for those people, but in terms of the European Convention, one of the criticisms is, oh, well, it keeps on changing. Well, the world keeps on changing. The world now, 2020, is different from the world in 1950, and is it not correct that our understanding of what people's rights should be also develops, and that the notions of pulling people up can develop, and we hold ourselves to a higher standard than perhaps governments were able to in the 1950s, because we've got a whole new set of circumstances as well as a whole new set of challenges. And the important thing is to try and reduce the gap. UK government talks about levelling up. That's absolutely right. That's what should happen. So the people living in deprivation, the people living in oppression, those are the ones that human rights are most important for. And yet, a lot of the time, those are the ones that are left behind, including in this country, which goes back to that question about is the Human Rights Act enough? Well, it's not, but it's better than not having it.
So you seem quite positive on the Scottish Government's record on human rights. So I think this might be quite an interesting question. So freedom of expression is a protected right under Article 10 of the European Convention of Human Rights, and by extension, the Human Rights Act 1998. In spite of this, the Scottish Government's Hate Crime and Public Order Scotland Bill has received wide-ranging criticism from various individuals and organisations, including the Law Society of Scotland, the Scottish Police Federation, politicians from various political parties, and even the Catholic Church, for its supposed jeopardising of the right to express one's views freely. So do you think the Scottish Government's Hate Crime and Public Order Scotland Bill is a threat to freedom of expression? And if so, could you tell us why?
I think it potentially is. And I saw some of that criticism, and I saw the Law Society of Scotland's criticism during the week, and I think the Faculty of Advocates had also offered some criticism of it. And I think it's gone a bit further than Lord Bracadale did in his report. So some of the wording just pushes it out a bit too far. And, I saw the suggestion in one of the papers that you wouldn't be able to read the Bible out loud anymore because of it. I doubt that that's ever going to be a real issue, but it is a concern, and I think, I would expect that it may well be amended and address some of these issues, because where you've got both branches of the legal profession agreeing that something's gone too far, and where when the government says, well, we're really just following on from what Lord Bracadale did, but then when you explore Lord Bracadale's report, actually it has gone further there. I don't think they've pitched it quite right. I can absolutely understand why they're doing it, and it's important to recognise that there are groups that say that this is important legislation that's needed, and it's some of the minorities that we've been discussing. But freedom of speech is absolutely fundamental, and I think this legislation doesn't get it right. So hopefully the government will be open to the possibility of some amendments that will do the job they intended, but without jeopardising free speech.
Perfect, thank you very much. So you previously said in the 2012 Scottish Parliament debate entitled "Making the Law Work for You" that human rights have frequently been used as a justification for reforms that may have yielded negative outcomes. You said slopping out as an example. So could you give us some other examples of where you think human rights were used as a justification, maybe for an unjust outcome?
I can't immediately, Rami, I can't immediately think of one. You've done your homework, certainly. I can't remember as far back as 2012. Slopping out was a situation where the then Labour Lib Dem coalition in Scotland received numerous reports, in particular from the Inspector of Prisons, but I think it was Clive Fairweather, maybe at the time, or one of his successors, that slopping out was just absolutely incompatible with human rights and had to go. And I think that the way it was presented was that they decided to give money to the Scottish Crime and Drugs Enforcement Agency instead. What happened then is that they fought a fairly lengthy judicial review in front of Lord Bonamy and lost it, and then ended up having to spend the money on ending slopping out anyway, as well as legal fees. And the legal fees would have been, not insignificant given some of the QCs involved and the length of time that the hearing took. So it probably was, government's in a difficult position and has to make choices, and that's probably, after the pandemic, the impact on economies throughout the world is going to be such that really difficult decisions are going to have to be made and priorities set. And it's been recognised that one of the as yet untold costs of the pandemic is on mental health. And that's of importance to me because I'm reviewing the mental health legislation. Resources in mental health practice were already scarce. There weren't enough practitioners. And that was having knock-on impacts and delays for people with serious problems at the time. People that really, frankly, shouldn't have been having to wait. And there's a risk that people with immediate needs will be prioritised too low down. But I suppose human rights can come into play in terms of using it as the sword to say, actually, my particular situation here demands priority. So there's scope for human rights again to kind of come into its own, but I can't immediately. There have been examples of. I think a greater problem has been misrepresentation of the Human Rights Act, and the Kentucky Fried Chicken story of the guy on the roof of a police station, some public building, in a siege type circumstance, saying, "I'm not going to come down, and you need to get me some food, so I want Kentucky Fried Chicken." I'm pretty sure the headline was along the lines that human rights to Kentucky Fried Chicken. What's the world come to? It's political correctness gone mad, and actually, and that's come up from time to time. I think occasionally some public authorities have hidden unpopular but correct decisions behind, certainly unpopular sometimes, behind human rights. And say, "Oh, well, we had to do that because of human rights." very often it's a misunderstanding of what human rights law would require. But it's unfortunately, it's contributed to this bad reputation that human rights have got, so that a lot of people see human rights as being a way for bad people to get what they want. Now, the test of human rights really has to be, do we apply them to everyone? Do we respect the human rights of people that we don't like, maybe despise, or who've done horrible things? Because the alternative to that, I suppose, and it's occasionally from time to time it comes up, say, well, what would ISIS do? What about the IRA if they're coming back into prominence? That they wouldn't respect people's rights. To which the obvious response is, do we hold ourselves to the standard of the criminals, of the terrorists, or do we hold ourselves to a higher standard? And my answer to that would be obvious, but it's when you try and translate that into action. Shamima Begum's another example from recently, where a lot of publicity, very skewed. It's understandable that there's going to be strong views on it, but when you think about the approach that's taken to children who, as they grow up, are being groomed for sexual offences or for human trafficking, and we're not applying those same standards or that same empathy to Shamima Begum, and the government takes populist action, refuses to let her back in, and then the courts are made to appear like the bad guys by saying actually she should be allowed to have her appeal from in this country, otherwise there's prejudice that may befall her, and that's the right way of doing it. And the response to that, human rights again kind of getting a bad press, whereas actually, and there's been some very good debate on social media about it, including people saying, she's our problem. It doesn't work when we're trying to extradite or deport people to their own countries of origin because they've committed criminal offences here. Whereas where it's one of our citizens who commits a crime abroad, and we then strip them of citizenship so that they can't be sent back here. Well, okay, that's a bit of a risky approach, because these other governments that we're trying to deport people to might say, you know what, we've stripped them of citizenship, they are now your problem. And I think the pretty poor argument that she could claim Bangladeshi citizenship, I think it was, it's very unconvincing. So occasionally you get hard problems. Guantanamo is another supposed solution, and Guantanamo every bit as much built by lawyers as it was by whoever would put the fence posts in. But it's just a dishonest way of dealing with and facing up to some of the problems of our times. But human rights are the light you can shine on some of these. So there's ongoing proceedings in America about Guantanamo, which should have closed a long time ago. I think Obama said he was going to close it, not closed. And so far as Shamima Begum, for example, absolutely it's right that she should come back here. If she's committed a criminal offence that's prosecutable here, then that's a possibility too. But let's recognise that we're applying double standards and try and avoid it as far as possible, and recognise that that kids can be groomed in exactly the same way for as appears to have happened to her, as happens with sexual offences, and they are pure and simple the victims. So life's not straightforward, and our victims are not always straightforward or sympathetic. And in the criminal courts, one of the things that you realise is that someone who's a witness or a victim or a complainer one day, the very next week could be the accused. There's quite a bit of overlap between the victims and the accused in the criminal courts. So life's not that straightforward. And I think government needs to show more leadership and recognise that and say, we respect everyone's human rights. And the test is, if it's someone you don't like, if actually you might be criticised for upholding their human rights, then that's pretty much the sort of situation where you should be doing it.
Well, thank you very much for joining us. This has been a great conversation. We've covered various aspects of human rights legislation within the United Kingdom. We also touched on your role leading the review into the use of COVID-19 powers by Police Scotland. So thank you for joining us, and hopefully we'll speak again in the future. Thank you very much.
Thank you, Rami. I enjoyed that interview.
Thanks.